in the club.
Welcome back to the Law&Crime Network, everybody. This is Jesse Weber. We're just showing you some testimony from earlier in the day in the Barrow, King, and Smith case out of Florida. This is when now the defense is putting on their case. Will it be successful? Remember, you have 3 defendants, 3 attorneys. It's a lot for maybe an uphill battle, but let's talk a little bit more about it. Joining me now is criminal defense attorney Andell Brown. Andell, good to have you here on the program.
Hi, Jesse. Thanks for having me.
Thanks for being on. So let's talk a little bit about what we have today. We know that Mr. Barrow has put on his defense. We saw the testimony of that man that you just saw. Actually, two witnesses that helped his case. First, it was, as you saw, Mr. Collins, and then another individual, Kiera Scott, who's Barrow's cousin. Now, we were anticipating that testimony, and these men have said that Barrow was not the shooter. After hearing so many witnesses come forward and put over by the state and say that Barrow was the shooter, now the jury's hearing that he might not have been the shooter. What do you make of this?
Well, the war of the witnesses continues. One of the things that we have to look at is the motive, interest, and bias. That's what we're looking at in every witness. Is there any reason or any motive this witness has to lie? It seems like all the witnesses presented on his behalf, they tend to be related to him somehow. They're a cousin, they're a friend, you know, so you have to take that type of testimony with a grain of salt, obviously. I have to say that the prosecution has come up with a lot more evidence than I thought we were going to see when I heard opening statements.
Do you think the fact that it's not so much concrete DNA evidence tying any of these 3 men? Yes, we seem to know that there were 3 guns, there's 3 defendants. Seems likely that, you know, the idea that 3 separate individuals in the club did this might not float so well with a jury. But the idea that it's really eyewitness testimony talking about these guys as the shooters, they were conflicting testimony, though. So not every witness saw the same things. Some saw, majority of them saw Barrow as the shooter. 2 only saw him, King, as the shooter. 1 saw Smith pass a gun to Barrow, but some have seen him as the shooter as well. When you have this conflicting testimony, how much is it the fact that it's a nightclub, it's a chaotic scene, a fight was breaking out, and how much of it is, as you said, war of the witnesses?
Well, you know, I think they go hand in hand. You have a chaotic scene. It's a nightclub, as you stated. People are drinking and other things may be going on. And we also have to acknowledge the fact that people don't remember things perfectly. This was almost 2 years ago when this occurred in 2015. Many of these people, so many other things have happened in between. Conflicting testimony is normal in this type of situation. The question you have to ask, or the question the prosecution has to answer is, do these conflicts happen on the essential issues, or are they just peripheral issues? I think the prosecution still has an uphill battle when it comes to some things, but the defense has a tough time fighting back against all of these witnesses. I mean, you have, even though there have been conflicting testimonies when it comes to Barrow, a lot of witnesses have said they saw him with a gun and they saw him shooting. There was a particle that came back where they did the GSR, the gunshot residue test, to see whether or not they could show that he fired a gun recently. And 1 particle came back positive for that. Even though the defense can explain it, it still doesn't look good for them.
Yeah, and did you find it compelling, the fact that Mr. Scott was holding back Barrow, that he had him in this bear hug, and the fact that he had him in the bear hug, he could have felt if he was holding a weapon. Then again, he's a bigger guy, and maybe the way he was holding him, he couldn't feel what was in his pockets. Did you think that was a compelling point put forward by the defense team?
I wouldn't call it particularly compelling. I think when you have a chaotic situation, you're trying to gain control of another person, you know, especially a person who's highly agitated, is moving around a whole lot. Obviously, he was struggling with him. He may or may not have felt that gun. I don't think it's conclusive proof of anything, because I think his attention was divided. There was a lot going on, and I don't know if he's not looking to feel what's in his pockets. I can't say that we should trust his recollection 100%.
Yeah, it's interesting. It's a debate about whether or not it's a credible witness, or whether or not maybe this is just what a person saw and heard. And so it might not be fair to say, from what they saw and heard, they didn't see a gun. They didn't see any of these defendants firing a weapon. But as the prosecutor said under cross-examination, it's possible. Isn't it not possible that you were ducking and you didn't see him firing? Maybe, maybe. Andell Brown, I want you to stick around because I do want to play some of the testimony that we saw earlier in the day from Mr. Collins. Again, when the defense started putting on their case, and when we come back, I'm going to be signing off. Rachel Stockman will be jumping in and talk with Andell a little bit more about this case as we do wait for live coverage. Again, they're in a lunch break, and as soon as we do have a live feed, we'll make sure to go to it. But here, in the meantime, is the testimony from Mr. Collins.
You were after the shooting?
Yeah, I walked up on her after the shooting.
Okay. Do you remember approximately where she was?
Yeah, she was, if you come out the club, she'll be to the left.
Okay.
Towards Pine.
All right. And when you observed her, first off, do you know Benitria before this?
Yes.
Okay, how is it that you know her?
We went, no, I met her through Facebook, but I know her from like around the community.
Okay. Do you know her family at all?
Nah, I didn't know the family.
Just her?
Just her, yeah.
Okay. All right. And there came a time where you were, after the case was over, that you spoke to the police, correct?
Well, you said after the case was over?
I mean, after that night.
The situation, the next morning we were at the station, but the officers turned us down.
Okay. Could you tell the jury about what occurred when you went to the station and who you went to the station with?
I went with Kiera, Shagarian, Sarah as well, and Jahan.
Okay. And did you speak to any officers?
In the midst of the officers bringing us in, they put us all in a room and asked us
Could you describe the room that you were sitting in?
There was a little couch in the room and little bookshelves. It was almost like a room you put a kid in to wait on their parents or something like that.
Okay.
Pretty much.
And while you were there, did they ask you any questions?
They just asked what colors we were wearing and told us we're good to go.
Okay.
That was it. They didn't.
When you say what color you were wearing, were they referring to your clothes?
The clothes we wore the night at the club, yes.
Okay. And do you know if they talked to Kiera or Sarah that day?
They turned Sarah around as well.
Okay.
I believe they talked to Kiera. I'm not 100% sure, but I believe they did.
All right. Thank you, Mr. Collins.
Yes, sir.
Cross-examination, Mr. Bankowitz. Cross-examination, Mr. Bankowitz. Whatever you want to call it. If you're adopting the witness, then you can ask direct examination questions.
Mr. Collins, how long have you known Gary King?
It's been years, since like 2008 as well.
How tall are you?
5'5".
Now, that night when the fight broke out at the club, did you see Gary in the club?
Yeah, Gary was in the club.
What was he doing?
I left Gary right before the fight. Gary was on the other side by the VIP.
So
and
you
I went
left?
Yeah, the fight broke out in the middle. I left from where Gary was and went to the middle.
And Gary left with you?
No, Gary stayed
Okay.
to the other side.
What was the next time you saw Gary?
Outside the club, directly across from the door.
Did he have any part in the argument between Nathaniel Kendrick and Mr. Barrow?
Gary had nothing to do with none of it. No argument, fights, nothing.
Did you see Gary King with a gun that night?
No, never.
How close outside did you get to Gary King?
Enough to touch his hand. I touched him.
Enough to touch him?
Yeah, I touched him.
And when the shots began, were you that close to him?
No, I was more close to the corner when the shots began.
Okay. Could you see what Gary King was doing when the shots were fired?
Yeah, he was
What was
hiding
he
behind
doing?
a car for cover.
Excuse me?
He was hiding behind a car for cover.
And was he in the same area that you were?
It was to my left.
But you could see him?
I can see him, yes.
You didn't see him reaching over, firing a gun, did you, over the car?
Absolutely not.
Did you see any of the individuals who were shot get shot?
I saw Benitria get shot.
Do you know a Patrick Emanuel?
Do I know a Patrick Emanuel? Yeah, I know a Patrick Emanuel.
Was he there that night?
Yes, he was.
And do you know a Devontae Gordon?
I'm not sure who that is.
Okay. Did you happen to see Mr. Emmanuel with a gun that night?
No, I didn't.
Did you see Mr. King leave the area
Leave.
after the shooting took place?
Yeah.
And when he left, could you see who was with him?
I believe he was by himself.
He was by himself?
Yes.
And did he leave in the black Kia?
Yes.
Did you see anyone leave the area in a Malibu, a Chevy Malibu?
Not that I recall, no.
Okay. And how did you leave the area?
I left with Terrell and Datron.
I'm sorry?
I left with Terrell and Datron, different car.
Okay. And could you see what car Mr. Barrow left in?
I believe he left in the same truck he came in.
Can you describe that truck?
It's a four-door, maybe like a dark brownish color. I don't know the brand or the name of the truck.
Pretty big size pickup truck?
It wasn't that big, no. It's not big as like a Ford 4x4. It's not that big, if that's what you're asking.
Well, you say Mr. King left alone.
Yes, sir.
And is it your testimony you never saw him fire a gun
Yes,
or
correct.
have a gun in his possession?
That's correct.
Thank you, sir.
Yes, sir.
Welcome back, everybody, to the Law and Crime Network. I'm your host for this afternoon, Rachel Stockman, and we are on standby as we await live testimony in the Cloud 9 murder trial, a trial we've been following here on the Law and Crime Network, gavel to gavel. You just heard from Jesse, who signed off for the day, and I'm here for the afternoon. We have Andell Brown, a criminal defense attorney in the very sunny state of Florida, on the phone with us. Let's talk a little bit more about this morning, because I have some questions about how these witnesses are going to go over with the jury, because all of them see, even though they're defense witnesses, they all seem to have a very close relationship with the defendants. Is that going to play into how the jurors view them?
I think so. As we look at these witnesses, as I said when I was speaking with Jesse, we have to look at what motive, interest, and bias do they have. Is there some motive other than this is what they saw for them to tell their story? In many of these instances, we have people who not only have different relationships to the parties, but some that I think we have to look at. They've been convicted of numerous felonies and other things like that. So credibility is an issue.
And especially, too, some of the witnesses, for instance, Kara Scott was one of the witnesses the defense brought up. And he said that he bear hugged one of the defendants, and he knew from the bear hug that the guy was not carrying. How convincing is something like that?
Well, to me, I don't find that to be particularly convincing, especially when, I mean, who is this guy trained in some special art of checking for guns while giving a bear hug and controlling someone in a chaotic situation? I don't think so. And I probably would have argued that he should not be able to give that testimony, because where's his expertise to determine whether or not someone has a gun simply by bear hugging them? So I don't find that testimony to be very credible or convincing.
Let's talk about the case in general. We're getting towards the end of the case here. We're probably going to have closings maybe this afternoon, probably tomorrow. Overall, this is a somewhat tough case for the prosecution because you have so many different eyewitness accounts with perhaps not the best memories of exactly what happened. You had some witnesses the prosecution presented last week who kind of recanted what they had initially told police. Some refused to testify. So kind of big picture here. How do you see this case going, and where do you see this case going?
You know, it's tough. I think on the one hand, the prosecution has to deal with the fact that you have reluctant witnesses, you have witnesses who have contradicted themselves in their previous testimony, and then you have testimony from witnesses that goes in so many different directions. That's what they have to contend with. On the defense side, I think what's tough for them is that you have several witnesses, particularly in the case of Barrow, that put the gun in his hand and say he was firing into the crowd. He was agitated. He was angry. So he has a motive. We know why he's angry. There was a fight involving his sister that spilled outside. And then all of these witnesses, even though you may be able to show that some of them probably didn't have the ability to perceive properly the events or recall them because of all the chaos and the confusion, you also have to ask yourself, why would all of these different people tell the same lie and put a gun in his hands when it didn't happen? So that's something they have to overcome. When it comes to the two other defendants, Smith and King, their cases are a little bit better because not that many people saw them or alleged to have seen them with firearms, and there's not a whole lot of proof. I think one of the major hurdles the prosecution has to overcome is who did what. I have yet to hear that question being answered. Somebody died. And obviously they were shot twice, once in the head, I believe once in the back. Which gun did that bullet come out of? Who fired that shot that killed her? Are they saying that, her murder, one person is responsible, or they're trying to claim that all three are responsible? This type of confusion only goes to the benefit of the defense because the prosecution has to prove each and every element beyond a reasonable doubt.
So you see kind of perhaps a split verdict here in terms of the defendants, perhaps Laquan Barrow being the one that may suffer the toughest consequences, perhaps with the second-degree murder charge, but Gary Edward King and Michael Eugene Smith, you think the cases are a little weaker when it comes to those two defendants?
Absolutely. I think King and Smith, the cases are weaker, and I think Barrow's attorneys may very well use the confusion of who did what to their benefit, because even though several people may say they saw Barrow shooting or firing a gun without determining which one of those shots went into which victim or whether all of his shots went into the air or they didn't hit anybody, how can they prove that he's guilty of murder?
And one of the things we had early on in the trial, so kind of how the sequence of this trial went, is we had many of the kind of more official witnesses testifying early, the detectives or the first responders who first came to the scene, the detectives, the firearms experts. And, with that more scientific expertise that we saw, we weren't able to get any testimony directly linking the weapons, the gun residue, any DNA to the three defendants that I heard. I assume that would hurt them.
Absolutely, that's hurts the prosecution. I believe there was one particle when they did the gunshot residue examination that they said they found on Barrow. They didn't conduct it on the other two defendants, but even one particle is such a small amount that can be explained by the defense. It can come in different areas, and I've seen many trials where that has been the case. And then we have to look at the lack of DNA evidence or fingerprint evidence on the 21 shell casings that were found on the scene. That doesn't look good for the prosecution. They've tried to explain it to say, hey, these things could have degraded over time. Whatever the reason may be, you have the burden, you got to prove it. People trust forensic evidence because there's no bias, it's viewed to be objective, and the state hasn't been able to come up with any that directly link the defendants, the guns, and the shell casings that were on the scene.
And we love having you on this show because you follow these cases for us so closely and really give us an accurate description of some of the witness testimony. We especially like having you on the show because you're a Florida attorney, and so you kind of know the ins and outs of how the system there works. However, I want to switch now to another case that we're going to be airing here on the Law and Crime Network, and that is the Tod Ten Hammer case out of La Crosse, Wisconsin. Jury selection is going on this morning, and we are expecting opening statements to happen around 2:30 East Coast time, 1:30 Central time. And this is the case of a man who is accused of intentional homicide for fatally beating his wife to death. But what makes this case really interesting is that he claims that this was all one big tragic accident where a airborne pipe pierced his windshield and actually struck her in the head. So he's saying he didn't kill this woman. It was all an accident. The police say, no, he staged this to make it look like an accident. We sent you some of the information. What do you make of this? Do you think it's a strong case by the prosecution?
I think the case is strong on the prosecution side because the devil's in the details here. When we look at his story, he says, look, this was all an accident. The pipe bounced off the street and, came into the windshield. That sounds like a pretty reasonable explanation. But once you get down into the details of the case, you look at the time frame. This allegedly, they left where they were around 7:53 in the morning. She had to be at work for 8 o'clock, and they were going in the opposite direction of where she works. Under normal circumstances, someone that has to be at work for 8 isn't going in the opposite direction at 7:53. Also, his excuse was that he had a windshield repair business and he was going to pick up a truck and repair it for a customer. The customer says, I made no arrangement with him to pick up my truck. He wasn't coming there to do that for me. So his story falls apart in many different issues. And on the forensic side, it gets even worse for him. The pipe, he says, came through the windshield. When they did the forensic examination, they determined that that pipe hit the windshield at least one time before it penetrated. So it seems as someone was trying to break it to make it look like it went through. The glass was on the seat when his wife wasn't in the car. There was no blood on the pipe. There's so many facts that make his story just look like it's all made up, and that's not going to bode well for him. His attorneys, it's their first homicide trial, so they're in for a wild ride.
Well, and also to add to some of the forensic evidence, the medical examiner's report, I was just going through some of that, and they did find she died from blunt force trauma. However, as part of the autopsy, they found fingernail scratches around her neck, which obviously would not be consistent with an accidental death where you just get a pipe thrown at your head accidentally through the windshield. So I think that you're right. This is going to be a somewhat tough case for the defense to get over these hurdles, because on its face, it seems like he could have a strong defense here. But as you said, as you get into some of these details with the timing of the forensics, the medical examiner's reports, things start to kind of slowly fall apart. But what I haven't seen in any of what I've read so far in the case is the motivation why he would want to kill his wife. Have you seen anything about that yet?
I have not. From what I read, there appears to be a history of domestic violence that spans several years. And what the prosecution contends is that on this day, he assaulted her as he had assaulted her in the past. And, at some point, there's also evidence they claim that she suffered significant injuries in the car before being taken out, not having to do with the pipe. And after he assaulted her and probably killed her based on his assault, he had to come up with a story. And that's probably what happened from the prosecution perspective. That's what they're arguing is what happened. So we don't know if there's any particular motive on that day, but it appears that there's a pattern of abuse and assault that has escalated, and perhaps this is the day it all came to a head.
Well, you know what's interesting too, and why I find cases like this interesting, you wonder if the defense is going to stick with that theory at trial. In other words, yeah, that's what he told the cops when they first approached and in perhaps subsequent interviews. But maybe they're going to go with the approach, yes, he killed her, but this wasn't intentional. It was somehow an accident or something like that. You just don't know.
Right. That could be an argument that they come up with. Perhaps it was an accident. After the accident happened, he panicked. And then he made up this story, not because he was guilty, but because he was scared of what would happen. That's definitely one way to look at it.
And also you have the fact that he called 911 right away. You have the fact that he says he did CPR, and I'm sure the 911 tape is going to confirm he did CPR on her, trying to resuscitate her. So these are all things that perhaps if they go under the theory of kind of an accidental death of sorts, could work to his advantage.
It could. There's also a passerby, a motorist that was passing by and said that they witnessed the car kind of pulled off to the side of the road in the ditch. However, the windshield was intact at the time and there was no one around the car. So that may kind of throw a monkey wrench if the defense decides to go with that theory, and may go back toward the prosecution's staging theory, where they're saying he probably, did what he did, may have outside of the vehicle and then came back and tried to stage the scene later, perhaps even before calling 911. So all of those things are questions that have yet to be answered because we're only in jury selection.
Well, it's certainly going to be an interesting case, Andell, and we're going to be streaming it live here on the Law and Crime Network. As we mentioned, approximately the schedule for this trial, they were having jury selection this morning, and we are expecting opening statements to be at around 2:30 Eastern Time, 1:30 Central Time, and we will be streaming them on lawandcrime.com, so be sure to check that case out. Back to the Cloud9 murder trial, the trial we've been watching all morning long. It's about 12:22 here in New York, and the case is expected to start back up in a half an hour. I want us to continue listening to more testimony from this morning. And Andell, if you don't mind sticking around for a few more minutes so we can analyze more of the testimony we heard.
I'd love to. I'm here.
Good morning, Mr. Collins.
Good morning, ma'am.
How are you doing?
I'm good, ma'am. And you?
Good, thank you.
Yes, ma'am.
Mr. Collins, you know my client, Michael Gene Smith.
Yes, ma'am.
How long have you known him?
Since about 2010 or 11.
So it's been several years.
Yes, ma'am.
Is he a good friend of yours?
He's an okay friend.
All right.
Yes, ma'am.
And you saw him at the club that night?
Yes, ma'am.
Did the two of you go together?
No, ma'am.
About what time did you get there?
11:30.
And you saw him in the club when the fight broke out or before the fight?
Yeah, I did.
And what was he doing?
They were just hanging out.
Okay. And when the fight started, do you know where he was?
He was on the side pretty much at first, yeah.
And did he get involved in the fight?
No.
Did he leave the club?
Did he leave the club?
Yeah.
Yes. We all left the club. Like, you mean go outside? Yes.
Yes.
Okay, yes.
Did you go outside about the same time he did?
Yeah, I'm the one that grabbed him out the club, yes.
Okay. And when you went outside, did you stay together?
At first we were together, yes. Then I left from by him.
And where was he when you went outside?
Straight ahead of the door. Almost to the sidewalk, I should say.
All right. And you both went out to the sidewalk?
Yes.
And then where did you go?
Then I went towards Laquan.
And where did Michael go?
I left him behind.
Did you see him after that?
No, ma'am.
Did you see him leave?
No, ma'am.
Did you ever see him with a gun?
No, ma'am.
Did you ever see him get into a fight or hand a gun to Mr. Barrow?
No. He just had words with Nate in the club, that was it, but he never got in a fight.
Okay. After the shooting, did you see my client there?
After the shooting, no, ma'am.
Did you see him at all that evening after the shooting?
No, ma'am.
Do you know how he left the club?
No, I don't know how he left the club, ma'am.
Do you know who he arrived at the club with?
I believe he came with Sierra.
Who?
Sierra.
Okay. Did you see them leave together?
I believe they're always together, so I'm pretty sure they left together.
Okay. Thank you, sir.
Yes, ma'am.
Cross-examination.
Okay, we'll get to that. You know him from high school?
Yes.
You know him from the neighborhood?
Yes.
You'd say you guys are cool, right?
Okay, yeah.
You know him for about 8 years?
Uh-huh.
Yes?
Yes, sir.
And you know Gary King?
Yes, sir.
You know him through Laquan?
Yes.
And him and Gary are cousins?
Yes.
You've known Gary for about 8 years.
Yes.
And you know Gene?
Yes.
You've known him. It's about 7 years now. Is it 2010 or 11?
Yes.
6, 7 years? You and Gene are friends, right?
Yeah, we're okay, yeah.
Now, Gene and Laquan, they're friends, right?
Yeah, you can say that. Yeah.
And Gene and Gary are friends.
The cousins, yeah.
Well, Gene and Gary are
Oh,
cousins.
I'm sorry, Gene and, never mind, yeah, they're friends.
And y'all are friends with one another.
Yeah, we're okay.
Y'all hang out?
Every now and then.
I mean, you guys go to clubs and stuff, right?
Correct.
You guys play cards together?
Me and Gary.
You don't play cards with Laquan?
Barely, he barely plays. Yeah, he barely plays.
But you do play cards with him?
Yes.
When you play cards, I mean, you're there together at somebody's house, sitting around, playing cards, talking, doing what friends do.
Gambling, yeah.
You guys gamble?
Mm-hmm.
Okay. And you play cards with Gary?
Yes.
Play cards with Gene?
No.
No? You used to go to clubs pretty often, right?
No, I was working a lot then, just every now and then.
Would you go on the weekends?
Yeah.
Now, you said you're okay friends with them, right?
Right.
I mean, you would agree you're more than okay friends, right?
No.
You agree you don't have many friends that you're closer with than them?
I have friends I'm closer with than them, yeah.
Okay. You said you're not good friends.
We're okay friends.
Have you ever said you're good friends?
I guess that's okay.
Mr. Collins, do you remember giving a deposition in this case October 19th of this
Yeah,
year?
I do remember.
I was there.
Yep.
Okay.
Yes, sir.
And Mr. Gorley was present, is that right?
Correct.
Mr. Bankowitz was there?
Correct.
Do you remember at that deposition saying that they were good friends?
That's okay as well, yeah.
I mean, there's a difference between good friends and okay friends.
Correct.
Okay. And you said they were good friends during your deposition.
Correct. Correct.
Okay. And you would agree you also that you don't have many friends that you're closer with than them, right?
Repeat that?
You would agree that you don't have many friends you're closer with than them.
I have friends I'm closer with than them.
But not many.
Yeah, not many.
Now, September 13, 2015, you were at Cloud 9 that night, right?
Yes, sir.
And you were there when the shooting happened?
Yes, sir.
How long do you think the shots lasted?
I wouldn't say a minute.
Not a minute?
No.
At least 30 seconds?
Roughly.
And after it was over, you went up to Benitria, didn't you?
I did.
You looked down at her,
Yes, I did.
and you walked away.
Yeah. I walked in the club.
You didn't try to give her first aid?
I don't know how to do that.
Didn't reach down, check for a pulse?
No, someone else, another female was down close to her.
And that night you're wearing, it's like a baby blue t-shirt, right?
Correct.
White shorts, right?
White shorts, correct.
And like shoes that have like pink and purple in them?
Pink and blue.
Pink and blue. How far was Benitria from Pine when you saw her?
She wasn't too far off from the. She was about 4 or 5 yards from the grass and stuff.
4 or 5 yards. That's about 4 or 5 yards. 1, 2, 3. It's about 4 paces.
She wasn't too far from the pavement.
What about how far from the pavement was she? From me to you? This far, a little further?
Roughly about there to the desk, between here and the desk. Yeah.
From me to that desk?
No, from me to that desk behind you.
Okay. 1, 2, 3, 4. About 5.5 of my paces, right? Yes?
Correct.
All right, you're there that night to celebrate her friend's birthday, right?
Yes, sir.
And that night at Cloud 9 was the Virgo birthday bash, wasn't it?
Correct.
And so everybody who had a Virgo birthday could get into the club free, right?
That's right.
But you got to RSVP ahead of time, right?
Yes.
And you were there with a friend of yours. I think you call him Bird,
It was his birthday. Yes, correct.
but you call him Bird, right?
Correct.
Bird's name is Josh.
Correct.
Joshua Rainey.
Yes, sir.
Yes. Also goes by China White.
I don't call him China White.
Go ahead if I could. Collins. States 62. Now you remember walking up to Gene?
Yes.
You remember you and Gene got pretty close, right?
Yes.
Close enough to hand him something?
I hand him something?
Close enough to hand him something should you have chosen to do so.
Yeah.
And who's that guy that was right to your right?
That's John.
John? What'd John hand Gene?
I don't know.
Handed him a gun, didn't he?
I didn't see.
And you didn't see Gene again that night, right?
No.
Do you remember what it was that, Laquan Barrett he was mad that night, right?
Both were mad. Yeah.
But Laquan was mad, right?
They both were mad. Yes.
And the witness be instructed to answer the question.
Answer the lawyer's question.
That's correct.
Laquan was angry.
Correct.
He was saying things that let you know he was angry, right?
Okay. Yes, sir.
Were you out there when he said, "Fuck the police"?
No.
What about when he said, "I should shoot the shit out of her"? You remember that?
No.
Shoot the shit out of him. You remember that?
No.
Remember him talking as he walked off about how he had bond money?
In the midst of them arguing, I wasn't paying attention to the argument. The words from both of them, I wasn't paying attention to.
What do you remember Laquan saying?
The words, I'm telling you, I didn't pay attention to them arguing words-wise. I would just...
That he had fire?
No words.
He was going to catch a body. You remember that?
Sustained.
And as Laquan's there, angry, it's Kiera Scott who's trying to hold him back, right?
Fair to say, yes.
But what actually gets Laquan to walk toward the parking lot is not Kiera Scott, is it?
I wouldn't know what got him to walk.
Well, you would agree that he started walking at the time that Michael Smith ran back up to him, right?
I didn't see Gene run up to him.
And people you remember everyone saying, "He's straight, he's straight, he's straight."
I was on the other side at that time, so...
What's that?
I was on the other side at that time.
Other side of what?
Where the front red carpet is.
Okay, that's where you were.
Yes.
And you didn't
So
hear
the argument where Quan wasn't, what Quan's saying, I'm not hearing it.
How far away were you at that point on the red carpet from Quan?
You want me to show you?
Yeah.
I'm still in this area. The argument, Quan's this way, Nate's right here. So I'm not hearing everything from over here with the commotion at the door as well.
Okay, so Nate's kind of on the first red bump
No,
there.
Nate's not that direction.
Quan's there.
Quan's that direction.
All right, so Quan's over here, and Nate, and you're over here. Nate, Quan, you.
You put Nate in the wrong...
All right, come on down. Just make sure everyone can see. All right, where were you?
I'm in this area at the time still.
And where was
Corn's
Nate?
there, Nate's there, and that's the front door.
And that's at the time that
The
Quan started.
argument was going on, so I wasn't hearing, there's still a whole bunch of people along this line. I'm not hearing what's Quan saying at all.
Doesn't Quan come back over here in this area, kind of between the red carpet and the road?
I never seen him get no.
And that's not when he begins walking back up.
No, Quan started walking from this way over here. I came this way.
So Quan didn't start walking from the street.
I didn't see him over here.
I have nothing further.
Redirect.
Mr. Collins, did you ever see Laquan Barrow with a gun that night?
No, not at all.
Did you ever see Laquan Barrow fire a gun that night?
Not at all.
Mr. Bankowitz.
So Mr. McCord asked you, and I missed this, but he asked you what you were wearing. What did you tell him you were wearing that night?
Baby blue shirt, white shorts, pink and blue sneakers.
And You remember what Gary was wearing?
Gary was wearing like a greenish outfit.
I'm sorry?
A greenish outfit. Greenish, yes.
He had pink on?
Did he have pink?
Yeah, pink, like pink in his shirt, bright shirt.
I can't say for sure.
That night, did he have what could be called a mohawk haircut? You know what a mohawk is?
Yes. I don't think so. No.
You ever seen him with a mohawk?
No.
Sir, do you have gold teeth?
Yeah, I do.
Smile for us. Top and bottom?
Yes.
Thank you.
Ms. Hawthorne?
And welcome back, everybody, to the Law and Crime Network. I'm your host for this afternoon, Rachel Stockman, also editor-in-chief of lawandcrime.com, where we are streaming many of these trials right on our website. It's about 12:38 East Coast time, and the trial in Florida will begin in about 22 minutes, so live testimony in the Cloud 9 murder trial will resume then. In the meantime, we have Andell Brown on the phone. He's a criminal defense attorney in Florida, giving us some insight on how he thinks the defense is doing. They're finally getting their turn in this case. This is the case, if you're just joining us, of 3 defendants who are facing second-degree murder charges for a brawl and then subsequent shooting that happened outside what's called a Cloud 9 nightclub. It's now called something else. We've had many witnesses take the stand pointing the finger at these 3 defendants, but today the defense put their case up, and they had several witnesses who, we should add, were close friends and or relatives to the defendants, saying that flat out they never saw some of these defendants with a gun and they didn't do it. What do you make of this, Andell? And how do you think the prosecution handled cross-examination of these witnesses?
Well, I think that, number one, the defense has to take the witnesses as they have them, right? The fact that they are friends and family, from the defense perspective, I would argue shouldn't be held against us. Those are just the people that were there. The prosecution on the other side has pointed out whatever motivation they may have to tell a particular story, their relationship to the different parties, the fact that, they don't want to get in trouble themselves, et cetera, et cetera. And I think also what has been brought out is the different testimonies that have been given at different points in time, as well as witnesses that took a long time to come forward. They're saying, if you knew all this information, if you knew this to be true, why didn't you come and speak up sooner? It seems like they're just saying, what the prosecution is implying is that they're just saying this now to try to get their friend or family member out of trouble.
And of course, it's going to be up to the jurors to determine whether or not they believe these folks that have taken the stand, these defense witnesses, are being truthful about what they saw that night, and whether or not these defendants had weapons in their possession, and whether or not specifically if Laquan was the one that opened fire, because a lot of the testimony this morning, has touched upon all of the witnesses, but all of the defendants, but several of the witnesses specifically addressed his role in all of this. And you've said, when we've spoken earlier, that you believe he's the one that has the tougher case in terms of his defense.
Right. It's just a matter of numbers. More people place him at the scene with a gun than anyone else. More people claim to have seen him shooting than anyone else. The testimony, even though it conflicts in various areas, once you kind of put it all together, there's more consistency with him being a shooter, him opening fire on a crowd, than you have with any of the other defendants.
So moving forward, what do you think the defense attorneys, and I say 3 because we have 3 defendants here and they all have their opportunity to give closings, what do you think they need to hone in on? If you were in that position, what would you do when they give closings?
Well, I think in that position, you want to remind the jury that the state has the burden to prove all of these elements to the exclusion of a reasonable doubt. And that's a very high burden, and it's high for a reason, because we're talking about freedom, something we value very much in this country. And I think the evidence, while you may be able to argue that probably these guys did something wrong, probably he was shooting because we've heard all of these people saying it, I don't believe it's been proven beyond the exclusion of every reasonable doubt. And I think that's what the defense would argue, and that's what they would focus on. They would focus on the conflicting evidence. They would focus on the fact that many of the people that are testifying, they may be taking a side. They may just be looking for someone to get in trouble because they're angry about what happened to somebody they cared about, whether they were hurt or, in the case of Miss Robinson, killed. You also have to look at the fact that they have witnesses that recant and admitted that they lied. At least if you believe that they actually, what they're saying when they say they lied, then you have to wonder, why is this going on? I think the defense has to focus on the conflicts in the testimony. And then the last thing that they would hammer home is the lack of evidence. We have no DNA on the shell casings. We have no fingerprints on the shell casings. We have no guns. No one has told us, what shot did what and which gun it came from. There's so much evidence that, in my opinion, the prosecution should have that they just don't have. And if I was the defense, I would hammer home on those things, on the conflicts of the evidence, on the lack of evidence, and the burden that the prosecution has to satisfy.
And again, if you're just joining us, so we are standing by for live testimony to begin again in the Cloud 9 murder trial, the trial we were just speaking about. The attorneys were specifically asked by the judge to think about and then get back to him if they are going to sequester the jurors or let them go home tomorrow. And because we're expecting jury instructions tomorrow and closings to last till about 3 o'clock. So what would you do in that scenario? Would you let them go home and have a fresh try at it on Wednesday, or would you just, while those closings are right on these jurors' mind, allow them to go into deliberations?
I would rather keep the jurors, until this case is over, if you can, right? Of course, I don't know all the logistics that they're considering or how long they expect things to take, but I think you touched on it. If you can have the jurors with everything fresh in their mind, because there's a lot of information, there's a ton of witnesses that the jurors have to, digest. As fresh as possible is, to me, it would always be best. I would like to have them sequestered so they can really remember what happens and really remember our arguments. They can be on their minds when they go into their deliberation.
Do you expect, just because of the complicated nature of this case and the fact that we have 3 defendants, we had 3 defense attorneys, and in this case we actually have 2 sets of jurors.
Yes.
Do you expect it to be a long deliberation? It's going to be actually a little unusual for us because we rarely have 2 sets of jurors, in that we're going to get a verdict, but that doesn't mean we get a verdict for everybody. We're going to get 2 different verdicts.
What I can say is that in all my years of practice and talking to other people who practice in jury trials, is that, you never know what juries are going to do.
Yes.
Everyone wants to act like they know, but no one really ever knows. It's really hard to predict whether or not they're going to deliberate long or it's going to be short, or even what that means. Many times people say, well, if they're deliberating for a long time, that means it's good for the defense. But then they might come back guilty, or they may deliberate for a short time. It could go either way.
In your trials, do you think it's a better sign when they're taking longer, though? Because that's what I've always heard on the defense's side. If they're taking a little bit longer, it means they're really reviewing this evidence again, and they haven't made their minds up going into deliberations.
Well, yes, I would say I would lean towards that school of thought, but it's not an exact science. I've won most of my trials. I've only lost 1 jury trial while I was first chair. However, I've seen many trials where juries deliberated for a while and still came back guilty. So it certainly happens, even though we like to kind of think that way. I really don't hang my hat on anything. We just do our best in the case, command the evidence, command the facts, make the arguments to the jurors, and then when they come with the verdict, they come with it.
Andell, so you've only lost one trial in your career. How many trials have you been part of? Not to brag.
I can't say I've kept count, but we're depending on the type of trial. We're probably talking about 30 to 40 jury trials at this point in time. And when I say one, that was where I was first chair. We win, at least I have won most of the cases we take to trial. And obviously, you're not taking every case to trial. You want to look at the different facts and the different factors and decide whether this case is a good one to take to trial.
Okay, so if you get in trouble in Florida, you know who to call up then. All right, that's a pretty good record there. Andell, I want to thank you so much for taking the time to appear on the Law and Crime Network, and always your insight on these issues and your thorough knowledge of the cases that we are covered is much appreciated. I hope you'll join us again. Thanks so much.
Thanks for the opportunity. Have a wonderful day.